Good evening to everybody. Welcome to the class. Yes, it is the moot court, and I'm dealing the moot problem 2, that is dealing about the family issues where the divorce and divorce by mutual consent, and the point they say the decision, then it comes to the matter of the conversion later on when the first wife is alive, and if the husband converted to the other religion, get married over there, whether it is amounts to what? Yes, bigamy, that is 494 of the IPC. And please read, unmute and read what I put on the screen so that I could know that you are hearing me and I am hearing you. Yes, please.
Happiness
Yes, please continue what I
can be
posted on the
far behind a grateful heart and a peaceful mind.
good.
Professor Dr. Mohammed Hussain.
Yes. And this is the quotation that I put it over there for the good evening salutation. Happiness cannot be far behind a grateful heart and a peaceful mind. A person who is having the peaceful mind and grateful heart, the happiness is very close to it. And that is the one of the slogan or one of the quotation which I want to share with you. Now let us come to our point of our study, and where we are discussing the yes, this is the one of the case law. Now you tell me, in this case law is helpful to the which issue of the appellant side, because there are four issues are there, and two issue and third issue also that we made it. Third issue very clearly says, what is the third issue? Sir, we don't know unless we have to see it. What is the third issue? Third issue says like this: if a person converted to the other religion, at that instance, can the spouse go to the court to take the divorce on the ground of conversion? So here answer is very much clear, yes, under the section 13, subsection 1, clause 2 of the Hindu Marriage Act of 1955. What it says, if any spouse, I say spouse, either husband or wife, doesn't matter. But here the conversion of her husband was a ground to get the divorce or not. So both the things that I put it over there, then you can say whether she could get it or not. But definitely the first married wife will get the divorce on the condition, on the ground that the husband has converted to the other religion. And without her consent, number one. And moreover, she doesn't want to convert also. And where he converting to get married to the another lady, and who is a divorcee in this case law, having the two kids. So here definitely would be there, because when you are arguing on behalf of the wife here, that is the petitioner, Virgil, appellant, in this case, at that instance we can say that yes, it is a very much good ground to take the divorce. But actually, she doesn't want the divorce. And she doesn't give the divorce by mutual consent also. The reason is, the husband should not supposed to marry the second one while she is alive. Okay, if she wants it, let the first marriage will be dissolved. That is the point. Yes, did you
Hindu,
get my point,
Hindu,
sir?
sir, Hindu embraces the community.
Embraces
Hindu
అంటే
means,
ఎంబ్రేసెస్ అంటే ఆహ్వానించుకోవడం. యాక్చువల్లీ ఎంబ్రేస్ అంటే కౌగిలించుకోవడం.
okay, okay.
So here that Hindu embraces a totally a different religion. See, Hinduism, he can be changed from the Jain to Buddhism, or Arya Vaishnava, or Sikh, or Jain. Can you say it is a conversion? Yes. They are all come under the definition of the Hindu. Because Hindu is a genus and Jainism, Buddhism, Sikhs and other are, it's only a, yes, species. That is a part of it from the genus.
Specie means
So, yes, yes, ask me.
specie means
ఇప్పుడు జీనస్ ఇప్పుడు రెప్టైల్స్ ఉన్నాయి. మీరు ఆర్ యూ ద బయాలజికల్ స్టూడెంట్ ఆర్ ఇన్ ద డిగ్రీ
history,
హిస్టరీ
arts.
ఆర్ట్స్ ఓకే ఓకే ఓకే. నౌ స్పెసి అంటే ఏంటిది? జీనస్ అంటే ఇప్పుడు ఇండియా ఉన్నది, ద ఇండియా ఈజ్ దేర్. దెన్ తెలంగాణ, ఆంధ్రప్రదేశ్, మధ్యప్రదేశ్, ఇట్స్ అ పార్ట్ ఆఫ్ ఇండియా. సో జీనస్ ఈజ్ ద ఇండియా అండ్ స్పెసి ఈజ్ ద ఇందులో భాగాలు అన్నట్టు. సో ద పార్ట్ ఆఫ్ ఇట్ ఫ్రమ్ ద జీనస్. The reptiles, in reptiles, there is a biological, the reptiles are there. In the reptiles, crocodiles also comes because the reptile, fish also comes, reptile. So these are the things. In mammalians, mammalian ante delivery istadi, mammary glands ఉంటాయి, milk ఇస్తారు. So in mammalian, a woman, a man also a mammalian, means woman here. And some whales are a mammalian. Whale. So genus is the broader one and a species is a part of it. That's why we can say that is genus. And here, when you say that, the point is religion changing means from Hinduism to the completely either Islam or Christianity or Zoroastrianism. So that way we can make it out. So one is a genus and another is a species. So the party who ceases to be a Hindu by conversion cannot file a petition for a divorce under this section. Suppose if he himself change the religion, can he file a suit against the another spouse? Answer is no. Because this ground can be claimed only by the other party, decided in the case of Rasna versus Arun case law. And there it is said that if the husband changed the religion or converted into the another religion or embraces the another religion or we can say converted into the another religion, at that instance, who is having the right to file a suit of the divorce in such a case? Yes? Tell me. Sir, I don't know. Say pass on. Neither pass on.
His wife, sir. His wife
His
can.
wife. Why you are taking that much time? Only the parties are only two. So wife can see one spouse means another spouse. If the wife changes the religion, at that instance, husband is having the right to take the divorce. But here in this case law, this first wife doesn't want to take the divorce because he wants that the husband should not supposed to marry the another woman, number one, and without dissolving the first marriage. Moreover, when the first wife is alive, one should not go for the second marriage under the Hindu law. So what she did it, no, she doesn't want the divorce in this case law. But if she wants, she can take the divorce because it is a good ground. So here Durga Prasad Rao versus Sundarshan, the Swami in the case law, they said in every case of conversion or reconversion to Hinduism, formal renunciation of religion or performance of the expiatory ceremony is not essential. Therefore, whether the conversion or reconversion took place in a question of fact. So in conversion, generally what will happen, there is something, suppose the Hinduism to the Islam. So when you want to convert it yourself, they say they have to approach to the Khazi or a Imam and he will read the Kalima and then he has to follow some of the morals of the Islam, and the name would be changed. So these are the things. Suppose from the Islam again he wants to come back to the Hinduism. Does he need anything? Answer is no. There is no ceremony would be there. Then he can come back and stay and be continue as a Hindu, and nobody would stop it. Nobody would stop it. Why your reconversion is taken place over there? So, but one certain conversion, there is something would be there. Yeah, something like from the Hinduism, the Christianity. Of course, the father will come and make a particular thing, then he will make it out. So there is a baptism is there. So these are the things. Certain things will be come out. But when you say come back again from the Christianity, the Hinduism, which is the original religion, then they need not to have any such a obligations should be there, such a rights should be fulfilled over there. So Hindu Marriage Act has proposed two conditions when a conversion as a ground for divorce can be invoked. These are. So when you want a conversion, what are the grounds should be available to the spouse? Means that the respondent has ceased to follow the faith of Hinduism. See, once he changed it, naturally he should not supposed to follow the faith of Hinduism. That he is no longer the Hindu. So once he converted it, he is no longer the Hindu, and he ceased to be the Hindu. Hinduism, follow the faith of the Hinduism. Number one. Number two, that is a B, that the respondent has converted to another religion, that is a non-Hindu faith. Yes, it is not a Hindu faith, it is a non-Hindu faith, because he is a Hindu at the time, but he converted to the Islam to get married for the Vinita, and who is a Henna Begum later part to change the name. So these first wives, they say, challenged not against the husband, they challenged against the act. How could a person would change the religion when the first wife is alive and the first marriage is not dissolved? So how could we make such a law to be there? And they say the Union of India, they challenged it. It is against the gender bias in that I already told you in the jurisdiction, and why she went to the court, because she was Article 15 and Article 13 and sub Article 1 ground also they made it, and that's why they made the party Union of India. But here if she wants to take the divorce, she can take the divorce, no doubt at all. But she doesn't want the divorce. Either the divorce or the dissolution of marriage, or of course divorce and dissolution of marriage is the same. And the divorce with the mutual consent. No. But the husband forced the first wife to go for the divorce on the mutual consent. So here there is one can be converted naturally. The other party is having a right to go for the divorce on the ground of it. But here in this case law, she doesn't want the divorce. So whatever the cases which I cited is there, it can be give the ground to the divorce, but she doesn't want to take the deal. Like a very Hindu wife converted to Muslim. See, this is very interesting. Where a Hindu wife converted to the Muslim faith and then married a Mohammedan. It was held that her earlier marriage with a Hindu husband was not dissolved by her conversion. Suppose if he converted, it doesn't mean that the first marriage is dissolved. She was charged and convicted for the bigamy for the 494 of the Indian Penal Code 1860. So Ram Kumari case law, it is clearly said that she committed it. But in the given case law, in our hand, that the proposition, Moot proposition 2, the husband converted it, and without dissolving the
Marriage.
yes, first marriage, the marriage, and the wife is
Hindu.
yes, no, wife is Hindu, no doubt, but wife is alive. So that is the thing. Then the husband definitely will attract the 494 section. What is 494 section?
Bigamy, sir.
I appreciate. What is bigamy?
Having two wives, sir. A person having two wives.
Then then what is the adultery?
Two wives or two husbands, sir.
Either two wives or two husbands doesn't matter, because both are married having the illegal sex.
Adultery is the having sex or sex with married persons, married
Yes,
persons.
that's why I told you, Joseph Shine versus Union of India. It is no more a criminal offense.
Yes,
Yes,
sir.
let us see that here. Then the question is, when a person is not dissolved the first marriage and the first marriage spouse is alive, then definitely it is amount to the bigamy. That is the fourth question here we can make it. But here also in every conversion there is a ground for the getting the getting the divorce. But here in the present case law, she doesn't want the divorce, nor the divorce by mutual consent and mutual consent. But the consequences of the conversion, let me see the Nandi alias versus Zainab versus the crown in the case law. What is say? Accused is Nandi, the Hindu wife, changed her religion to Islam, and thereafter married a Mohammedan. It was held that mere conversion of the to Islam did not dissolve the marriage. I already told you. Merely changing the conversion, it did not dissolve the marriage unless until you have to dissolve it. Or you can take the divorce by mutual consent also. With the petitioner automatically and consequently, she was charged with the bigamy under the section 494 of the IPC. So, without dissolving it, if you could go for that one, it is amount to the bigamy. So, conversion is not itself give the ground for dissolving the first marriage. That is the I want to impress upon you with this case laws. And Sushmita Ghosh versus C.G. Ghosh and the consideration of the totality of the facts and circumstances of this case, the plaintiff is entitled to the maintenance. She is also entitled to separate residence after balancing the equities in my it may in my considered it may consider in my the person is making in my consideration opinion the plaintiff is entitled for the 5,500 per month towards the maintenance of the 2,000 per month towards the separate residence. Here, if any person changes the religion or converted to the other religion and without dissolving the first marriage and the wife is alive over there and that person has to give the maintenance to the first wife as well as the children are there, the children also he has to supposed to give it. Sir, there is no divorce, no sir, that is not because he deserted her and the wife as well as to the children. And at that instance she can ask for the maintenance even though there is
Under
no
CRPC
divorce.
125, sir. Under
Yeah, yeah,
CRPC
yeah.
125.
Yeah, it will applicable to each and everyone, irrespective of the caste and creed. Yeah,
All
the
all of
defendant had been paying 2,000 entry maintenance per month. The plaintiff, why? Because he changed it, and at that instance he committed an offense, and he is supposed to pay it. Because when a person has did such a thing. So now let us see the another case. In the suit filed by the plaintiff is decreed with the cost of the aforesaid terms. Then in the present case law, what had Gyanchand had to pay maintenance and separate registration shall be paid by the defendant to the plaintiff Shushmita if the Shushmita wants the maintenance for her life. Yes, and every 10th of the every calendar month she has to pay it. Who? The Gyanchan, because the reason is that and he deserted the wife. Number one, even the wife stayed over there. That is a different issue. And does any marriage instituted after conversion to a Muslim? Well, marriage is already remains before the conversion is void. So now that it is not a void, of course, conversion, getting married to the another person just for the sake of the marriage, then such a marriage is void. So, this is the Tista Chatoraj versus Union of India. This is the one another case, and where it says conversion to another religion is a ground for divorce. Yes, it is a very much true fact. Nobody denies it. But a spouse may be denied divorce even if the other spouse has embraced some other religion of the former, goaded the and later such a conversion. So now the question comes over there. Suppose if she herself has goaded her to change the religion, at that instance she cannot ask for the ask for the divorce on the pretext of the conversion, because she is also involved there to change the religion of a husband or the spouse. At that time, she cannot claim the chance, because the theory of equity says over there, if a person wants to go to the court, he should go with the clean hands. Are you following?
Yes, yes, yes.
That's all.
Because ఇద్దరు దొంగలు దొంగలే సార్, we are we are making a theft, but we agreed that 50-50% can they can go to the court, sir, that fellow is not giving the 50% in the looted booty. First of all, either both are culprits, both are
दोनों
thieves.
के अंदर बस
ये
दोनों
दोनों
के
के अंदर डाल दो, sorry, we should not say that, because generally the police fellows and other fellows will use such a terminology.
साहब साहब हैदराबाद लैंग्वेज है वो हमारा हैदराबाद की लैंग्वेज है वो
So, so that is the reason that they cannot go to the court. The reason is, a person who wants to the court, he should go with the clean hands. So that is very important factor. So here, if one of the spouse converts his religion to any other religion without the consent of the other spouse, then the other spouse can approach the court and seek a remedy for divorce. Yes, if she want, she can take the divorce. But in our case, in the case law, she doesn't want the divorce, because she wants to see that that fellow should be punished under the bigamy 494 of the IPC. Plus, they want to challenge it. It is indiscriminate and the bias, gender biased, and hence she filed a case against the Union of India. Of course, there are, I cited so many cases, but this is very easy case, because the fourth one is very easy to make it out. There are 3 to 4 case laws are there. Among them is the Sarala Mudagal case law, is a very famous case law, is the 1995 case law is there. Later case, Lily Thomas versus Union of India 2000 case law. These are the two. One should have to definitely write it to support the stand over there. And these two case laws say the same rule, same principle. If a person, means if your spouse wants to convert into the another religion, yes, he would have every right to convert it, because conversion is allowed over there, and it is given by the constitution also, such a thing. And but the only thing is, if she married over there, then the first wife should be, for the first marriage should be dissolved, number one. Number two, while the wife is alive over there, you should not go for the second marriage under the Hindu law. Under the Hindu law. So at that instance, but here in the case law, present case law, it is very much clearly shown over there. What is shown? Already she is having the wife. Who? The husband is having the wife. Yes, both are Hindus. Okay, well and good. They live sometimes together. Very good. But later on, of course, she deserted the husband, because she deserted. The reason is, if she goes to the husband house, then the husband make the domestic violence, number one. Number two, even the husband, all relatives, including the father, mother, sisters, brothers, and rest of the other relatives, also make the cruelty over her and treat her as a housemaid. So that was the reason that she did not go over there. That's why I made it proved there in the first issue that she did not desert her, because she doesn't have intention to make such a thing. That is the reason. But what is the reason she stayed over there in the father parents' house? Because if she goes over there, again the domestic violence with the husband and the husband side people, including the cruelty. So it is not amount to desertion that I said in the first issue. And the cases also that I mentioned in my yesterday class. Yes, yesterday class I mentioned a Niraja case law, if I not be mistaken over there. Yes, but here in this case law, what I told you, these two cases are very much important. What is the Lily Thomas and another case law is the Sarala Mudagal. In the Sarala Mudagal also it has happened. There are 4 writ petitions are there. The four are having the same thing. Husband change the religion, or if the wife change the religion without dissolving the
First marriage.
first marriage, and when the spouse is
Alive.
alive. If these two conditions are there, then the legs were fettered. అర్థమైందండి ఏమన్నా? Did you get my point? The legs were fettered. Fettered. చైన్ వేస్తారు అన్నట్టు. బట్ ద లెగ్స్ ఆర్ ఫెట్టర్ మీన్స్ చైన్ వేసేసారు సో దట్ హీ కుడ్ నాట్ మూవ్. ఇప్పుడు సపోజ్ ఇఫ్ ఎనీ బుల్ ఆర్ హార్స్ ఆర్ ఏ బఫెలో ఈజ్ రన్నింగ్ అవే, వాట్ ద పీపుల్ డూ మిడల్ ఏమేస్తారండి? ఒకటి కాళ్ళకు దడతా ఉంటుంది చూడండి. వాట్ యు సే దట్ థింగ్? బంధం వేస్తారు. దర్ ఇస్ ఎ బాండ్ వుడ్ బి దేర్. దర్ ఇస్ ఎ లాగ్ ఈస్ దేర్, అండ్ దట్ లాగ్ and around the neck, the log will not allow the buffalo to run. And if he move also, is a move in a slow pace, because the log will hinder the pace also, slow down the pace. So that was the thing. And so he, yes, please.
इसमें साहब वो when the wife is deserting her husband,
Okay.
whatever may the issue,
Okay.
will it not useful for that husband to ask for the divorce?
Yes, I told you, no, we are arguing on behalf of the wife. At that instance, we have to try to protect the wife, to say that she did not desert the husband, but she deserted because of the fear of domestic violence created by the husband, as well as the husband side people shown the cruelty over there. With that fear that I have not gone to the husband house. So High Court has accepted the reason. The reason is, no, the husband is failed to prove that they could not do such a thing. Which one? Domestic violence, as well as the cruelty. If this not failed to prove this true, naturally the wife is having every right to stay with the parents. So it is not a mode to desertion, I said in the first issue. So to whom that you are protecting, and that is very important factor. On behalf of the appellant that you are writing the memorials here, so try to protect your client as much as you can. So we can say that she has not deserted, and because of that protection, she was staying over there. Hence, it is not amount to desertion. Even though it is more than 2 consecutive years she stayed over there, but her intention to come back, but that fear made them to not to come back to the husband matrimonial home. So that was the point where we can make it out. And here in this case law, wife is alive and no dissolving of the marriage, the first marriage. The husband changed with the other religion, converted into the other religion, and get married for the sake of only marriage, not to follow the religion of Islam or Muslim. If such a thing would be there, Sarala Mudagal case law also gives that 494, the husband would be liable. That is bigamy. And the Lily Thomas case law versus Union of India also, the husband is liable under the 494. The reason is, first wife is alive. Second reason is, yes. Second reason is
conversion of into another religion without consent of the first wife, sir.
No, consent is not there. Okay, I admit there is a good ground for that, taking the divorce. That's the third issue. But when they say in the fourth issue, the husband would be liable on the 494 of the bigamy, And the first point is when the first wife is alive, and the second point is
Should not take another marriage.
you are
It
just
will not be
missing.
dissolved.
Dissolved. That is the point. Yeah. The first marriage is not dissolved over there. At that instance, you are not supposed to go for the second marriage. So, these are all the cases where 4 writ petitions are having the same reason and the issues laid with the same issues. Whether the Hindu husband married under the Hindu law by embracing Islam can solemnize the second marriage. There is a issue in all in the Lily Thomas case law or Sarala Mudugal case law. Whether such a marriage without having the first marriage dissolved, see, under the law would be valid marriage, the wife would continue to be a Hindu. The wife will be continue to be a Hindu, and there is no dissolution of the marriage. There is a second point, second issue. The third issue, whether the apostate husband means change the one religion to another religion would be guilty of the offense of the 494 of the Indian Penal Code. So these are the all the issues are there in the Sarala Mudagal case law as well as the Lily Thomas case law. Then I will tell you another case law also, because I do have the list of the cases where you can make it out. But if you write the 2 cases, I feel that you have written more than enough. So that was my thinking. So now let me see. Yes, I cited some of the cases. No, here it is now. At least 4 cases are there I cited, and in the 4 cases, if you write the 2 cases of such a nature, that is very good. Moot court propositions, yes. And here we can make it out. Yeah, I found it. Is it the same? This is the another case now. Moot court, very first proposition. Yes, it is here. And where it is made it very much clear. Moot proposition final PDF, yes. So in this, at least 4 cases are there where you can mention, and that case law is Sunita and Fatima versus Union of India. If you want, you can take the screenshot also, or when you are referring it in the YouTube also, you could see those case laws. And the Lily Thomas versus Union of India and others 2000 case law. Mr. Sushmita Ghosh versus Union of India, because she wants that maintenance should be given over there. Number 1, number 2, and if the children maintenance should also be given over there, and the point they made it. And next is Srimati Sarala Mudgal, that another organization is the NGO organization president, Kalyani and other versus Union of India and others. And Sunita, of course, the Sunita and Fatima already I mentioned. So if these 4 case laws, if you mention, it is enough. Of course, you can consider the Bipin Chandra also, even Suresh Babu also, that we can make it out to support it. But Suresh Babu versus Leela is mostly useful for the conversion. But in these 4 case laws, you can use it under the, which I highlighted in the red. Can you read it? Can anybody will read it what I highlighted there on the, so that I could know that you are present, number 1. Number 2, you could see it.
Sunita and Fatima, Union of India and others. Lily Thomas versus Union of India and others, 2006 Supreme Court cases 224. Mrs. Sushmita Ghosh versus Union of India and others. Srimati Sarla Mudgal, President Kalyani and others versus Union of India and others.
These are all the cases you will say that when the first wife is alive, number 1. Number 2, when the first marriage is not dissolved over there, then the other spouse could not embrace any other religion and get married by changing the second woman into the other religion. It amounts to the bigamy. That is 494 of the IPC. So these are the cases where we can say the fourth, it is clearly mentioned that yes, it is amount to the bigamy, one should not supposed to do it. And the same thing which I made. See, Lily Thomas case law I mentioned here. See, Lily Thomas, etc. versus Union of India and others. That is ALD. What is ALD? ALD CRI means criminal. What is ALD? I gave you all the type of. I have not given the type of the cases.
Allahabad criminal.
Allahabad. So you want to see that you should be Allahabad. So type of the cases. No. Abbreviation general. I said. No, type of the cases. No, abbreviation of the journals that I said. General abbreviations. I sent to you a general abbreviation. See, this I sent to you already. You check it ALD. What is ALD? Here it is given ALD or not. AR, All India Reporters, Mysore, and ALMR, ARC. Here ALD is not given. No, ALT is there, and ALT is there. They have not followed the alphabetical order. See, here I highlighted. Did you see it? Did you see it? Shall I magnify it? Yes. What is ALD?
Andhra legal decision.
Yes, it is from Hyderabad. ALD is there, and very adjacent to the AR office, opposite to the High Court, where you can find the Asia Law House. Then you find the adjacent to the Gogia Law House. Then adjacent to that you can find the AR office and ALD office also. Andhra legal decisions criminal. It is mentioned over there, that case law. And next, yes, that is the Lily Thomas case law. And even Sarala Mudugal also is having the same ground, stating, what is that stating? That the court dealt with the issue, namely whether a Hindu husband married under the Hindu law by embracing Islam can solemnize the second marriage, whether such a marriage without having the first marriage dissolved under the law would be a valid marriage for the first wife who continued to be the Hindu. The first wife doesn't want. Suppose the first wife wants to convert into the Islam. Now you tell me. Yes?
It is valid, no, sir.
There is no question of any other issue, because husband can handle the two wives. And the first wife give the consent, yes, I would like to change the religion to the Islam. Yes? And he is having a lot of, and that fellow is both financially sound and biologically very fit. So at that instance, if they want to make it out. No matter if she agrees. And there is no issue at all. See, even now also you could see some of the Hindus here having the two wives. Can anybody will go to the court of the law? If so long that nobody would go to the court of the law and tap the door of the court, why other people are worried? Why other people get the stomach ache? Tell me. Unless until they have the vested interest. Are you following me?
Yes, sir. Yes, sir.
Very good. So, the first wife is alive over there, one should not supposed to do. Whether the apostate husband would be guilty of offense, means a person who has changed one religion to another religion, and under the 494, whether he committed the bigamy or not. The holding arrived in this matter can certainly be considered as a timeless ratio worth including this category. And they say, yes, it is amount to the 494 bigamy, and when the first wife is alive there, one should not supposed to go for the another marriage. And the Lalchan Narwali, that is another case law, Mahant Ram Rupgir, I don't know what is a Bombay Law Review, BOM Bombay Law Review. Sir, is it law review or law reporter? Again doubt. Because when such a doubt would be there, what we have to do? I already gave you what? Journal abbreviation. See, Bombay and law reporter, not review. See, here I highlighted. Did you observe? See, Bombay law, not review. So most of the people don't say review, better say reporter. Bombay law reporter, unless there is a need for to say. Otherwise, you need not to say anything. Are you following me? So, in this case law also what they said, the second marriage is void. Even if it is not declared as void, a third party is interested in the marriage, the first wife can also get the second, and second marriage declared as a null and void. So the point is, unless until if somebody will be interested in that one, and nobody would say that there is a void marriage or one should not commit a bigamy or not. If the wife agrees to that one, there is no bigamy at all. Which wife? First wife. All the four ingredients of the section 494 of the IPC should be satisfied. Then only we can say that it is a bigamy. Otherwise, we cannot say that bigamy. So, in the given scenario, the husband married the second wife without dissolving the first marriage. And when the first valid wife was living, at the time, the husband committed the offense of the bigamy under the section 494 of the IPC when he converted to the Islam and made the another lady, Vinita, also as a Henna Begum, change the name and get married because he changed it to just to marry the Vinita. Now I told you that the celebrity is married. Can you tell me which celebrity is married to whom to whom? I discussed it in the class at least 2 or 3 times also with their photographs.
On Kalyan.
Yes. Paul Cannell married to whom?
3.
Muslim, Christian.
Christian, Hindu.
So now which wife is having? Both. Tell me. See, I already gave that example of the Dharmendra and the Hema Malini. Both they changed their religion and they got married and conceived also 2 children. Then Mansur Ali Khan Pataudi versus yes, Sharmila Tagore. They changed into the religion, they got married. What about the son of the Sharmila Tagore?
Muslim only.
What is his name? And who married? A Hindu.
That person, sir.
Saif Ali Khan married the Kareena Kapoor, not under the Hindu Marriage Act, not under the Islamic marriage. It is married under the Special Marriage Act. In the Special Marriage Act, one need not to change the religion. So, if any person wants to get married over there, let them marry under the Special Marriage Act, irrespective of the religion. But when the first wife is not alive, next the first marriage is dissolved, then only one can go. When first wife is alive and the first marriage is not dissolved over there, if they go for the second marriage, either by changing the religion or by any other means, and they have committed the offense of yes,
Bigamy.
under which section
494. sir.
of what?
IPC, sir.
IPC is the acronym or abbreviation?
Acronym, sir.
It is a purely acronym. Like here, I highlighted this one. I don't know whether you could see it or not. Did you see it? I made it red.
Business law report.
What is that? Can you read?
Business law report.
Yes. Now, whether it is a acronym or whether it is a abbreviation. Yes. Anyone?
BUSL, sir. BUSL.
When you say BUS, when the first letter is a capital letter, rest of the letter is a small letter, and at that time we definitely will say it is an abbreviation because LR is, even though it is an acronym come, but totally we can say business law review. reports, we can say it is the abbreviation. So these are all things also you should have to remember. Company case law, company law journal, company law report, consumer protection judgment, and contracts and tender law journal. These are all the abbreviations of the journal. Sometimes you have to remember it, and when you are writing it, there is an important factor. So now, who is this man? Yes?
Professor Hussain, Mohammed
Jana
Hussain.
Hussain Saab. Jana Hussain Saab.
Whether I am reflecting the same thing or I am got it changed.
Nahi saab.
Professor Mohammed Hussain.
Then who is this?
Same saab.
Same.
Then what is the difference between the first one and the second one?
First one
Dress,
is
dress,
suit,
dress,
sir.
dress, dress.
Color direct color.
No. That's why I want to check your IQ. See, I want to check your IQ. There I had the coat and tie, but here I did not have the coat and tie. So that is the reason that I haven't shown you. So now I should appreciate it. The legends are participated in the today class and they gave the answer also. I felt very much happy because this age also you are having such enthusiasm. You learn the things, then you will be a good role model to the your new generation, to the people, those who want to learn. Because for the learning process, there is no age. Is it clear?
93 years man has got PhD.
See, that is already gave the viral. It is given over there in the WhatsApp group. And not only that, he is having many other degrees also. In addition to that one. So, for the learning, there is no limit for the age. Sir, tamarind. Tamarind, do you know what is tamarind? Yes. ఇది చింతమండు ఎంత వయసుదైనా ఎంత పాతదైనా అది does it lose its soreness? it doesn't lose its significance. So a person who is clearly a learner and wants to learn it thing, and death is the end. Death is the end. And today I have dealt total 4. Of course, I took at least 3 to 4 classes only to deal with the cases of these issues.